From supplementary list for orders item 1, Criminal Division 1278 of 2016. Lower court से report मांगते हैं.
Post this case, but this is Criminal Division 1278 of 2016. Post this case on 16th of October 24. Post this case on 1st of October 24, awaiting the report from the concerned court. Office to sender express reminder. Also for the status case.
From daily list for final disposal item 1, Criminal Division 1373 of 2016.
Petitioner has been convicted for the offence under section 409 of IPC laws. He has punished for 1 year in prison. Out of that means he has for 6 to 7 months he is from 6 to 7 months he is in custody. He has served the term. 409 the punishment is
What is the period during which he has to be in custody?
On the first occasion was 23/1998.
20 दिन.
20 दिन हाँ से 22/9/1998 6 महीना.
1998 to 22/3/1998.
After that was
23/98 to
22/9/98 was
22/9/98.
6 months.
Okay.
And during the pendency of revision was 23/2017
2017
to 10/4/17. Although he was granted bail on 6/4. 6 months 20 days 22 days.
What is the age of the petition?
67 years.
Are you sure?
Yes.
As per the records?
As per his Aadhaar card.
As per the records.
As per
313 case up.
his matriculation certificate also.
No, we will see only as per the records. We are not concerned with the
In the
matter.
313 months, the age has not been mentioned.
Not possible. नहीं sir.
313 जो मेरे पास
HCR
है,
है? नहीं. जजमेंट के दिन का एज तो दिख रहा है. 313 के बाद ही हो जाता है जजमेंट.
313 में उसको एज लिखा हुआ नहीं है.
जजमेंट में जो एज लिखा हुआ है वही पकड़ेंगे हम. What is the name of this person?
भुवनेश्वर प्रसाद.
Bhuvneshwar Prasad. He was 57 years on in the year 2013. So 67 हो गया ना?
67 हो.
More than 67. Any other criminal case?
No. Yes.
What about the other co-accused?
They have been acquitted by president.
What is the allegation?
It was defalcation of money amounting to rupees 34,000.
Just a minute. This is I have defalcation of money of rupees
32,547.
32,005
145.70 paisa.
32,005
545 crores.
45 point
70 paisa. And at that point of time, this petitioner was postmaster of Ramgarh Kent Post Office.
let us see the finding.
That's right.
Yes, let us see the finding.
Appellate court finding is at page number 50. Page number 50.
Just a moment. You just tell me the prosecution story from trial to judgment.
Look, the instant case was set in motion on the basis of written information. Page number 26. Given to the officer in charge of Rajrapa Project PS Police Station by Ramasankar Singh, Assistant Superintendent of Post Office, Ramgarh Sub-Division, Ramgarh Kent, alleging inter alia that Rajkumar Sasi, posted as an assistant at Chitarpur Post Office in connivance with Bhola Prasad, Assistant Postmaster of Chitarpur Post Office, fraudulently withdraw rupees 63,745.10 paise from the two saving accounts, one CTD account, on the basis of false passbooks, SB10 transfer forms and other false forms. It was also alleged that above named Bhuneshwar Prasad in connivance with Bhola Chaudhary, the in charge of saving bank branch of Ramgarh Kent Post Office, further withdrew 32,547 paise from Chitarpur saving bank account number such and such belonging to one Virendra Kumar. The details of the withdrawn money by the accused persons were given in an annexure attached to the written report.
I received it. And where is the finding of the trial court?
Page number 28, EW1.
No, finding of the trial court.
Yes, page number 28.
No, final finding. That's what
That appellate court.
para 21. Trial court. Para 21.
Page 42. Thus, all the oral and documentary evidences adduced by the prosecution clearly prove that these three accused persons working in their capacity as public servants conspired together and committed cheating, criminal breach of trust and forgery. They used various means to create false documents like passbook, SB10B and SB7 forms on the basis of these false and false documents. False accounts were opened in the name of fictitious persons. False entries were made in the various journals and registers of the Chitarpur Post Office, and ultimately, huge amount of government money was withdrawn from those accounts. It is an admitted position that accused Bhuneshwar Prasad was working in the capacity of sub postmaster at Chitarpur Post Office at the relevant time, and therefore he was the custodian of all the deposits and government money at Chitarpur Post Office. It was the duty of the Bhuneshwar Prasad to verify any request for transfer of any account from the relevant post office. However, without verifying the genuineness of the account, he accepted the transfer from the passbook produced by Kumar Sasi and Bhola Chaudhary, the two other accused persons. And on their oral request, he not only opened new accounts in the name of fictitious persons in his post office, but also handed over money to them. It is strange that before finally closing the accounts, Bhuneshwar Prasad did not ask for physical presence of the depositors. Rather, he handed over money to Rajkumar Sasi and Bhola Chaudhary. Thus, all the ingredients of section 409, 420, 420,
this respondent, what do you have, anything else you want to say? What do you have to say?
हेलो
क्या बोलना है आपको?
की पोस्ट मास्टर थे चितरपुर पोस्ट ऑफिस में और दो और लोग भोला चौधरी और राजकुमार शशि के कोराइमेंस में बिल गवर्नमेंट के मनी को डिफॉल्केशन किया इसके चलते इनको एक साल का सजा हुआ
अपीलेट हो रहा है
49 में 2000 का फाइन
other 2 persons have been acquitted. Page 55.
Or the learned counsel appearing on behalf of the parties. This revision is directed against a judgment dated 3/8/2016 passed by learned Judicial Session Judge 1 Ramgarh in criminal appeal number 14 of 2013, whereby the petitioner has been ultimately, the appeal filed by the petitioner has been dismissed.
Pardon me.
Whereby the appeal filed by the petitioner has been partly allowed and the petitioner has been acquitted for offence under section 420, 467, or 120 capital B of IPC and has been convicted for offence under section 409 of IPC. The sentence of the petitioner has been modified by the Learned Appellate Court and has been ultimately sentenced to RI for 1 year with fine of ₹2,000 with default sentence. The petitioner was convicted with other co-accused by learned Judicial Magistrate First Class Hazaribagh in GR number 1310 of 1997/GR number 105 of 2013, while judgment dated 4/1/2013 for offence under section 409, 420, 467 and 120 capital B of IPC. The learned counsel appearing on behalf of the petitioner has submitted that the petitioner has remained in custody for about 6 months for the period from 23/1998 to 22/9/1998 and for further period from 23/2017 to 10/4/2017. And total custody of the petitioner is about 6 months 22 days. He has further submitted that the petitioner is 67 years of age as on date. He has no criminal case against him as per the impugned judgments, and there is an allegation of defalcation of 32,545.70. And at the relevant point of time, he was the sub-postmaster at Ramgarh Cant. The learned counsel has submitted that the appellate court has considered the appeal of other co-accused persons along with the appeal filed by the petitioner, but the other two convicts were acquitted and the petitioner has been convicted, were acquitted and only the petitioner has been convicted. It submits that considering the fact that the case is of the year 1997 and much time has elapsed from the date of the incident, and considering the age of the petitioner, some sympathetic view may be taken and sentence be modified. The learned counsel appearing on behalf of the state while opposing the prayer has submitted that there are concurrent findings recorded by both the court and the matter involves defalcation with money of the depositors in the post office, and he submits that both the courts have considered the materials and the appellate court has reduced the sentence of the petitioner from 3 years to 1 year, and therefore the petitioner does not deserve any sympathy of the court. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, Mr. Badikura, no other argument has been advanced from the side of the petitioner. After hearing the learned counsel for the parties and considering the facts and circumstances, this court finds that the prosecution case is based on the written information given to the officer in charge of Rajrappa, project, PS case by Assistant Superintendent of Post Office Ramgarh, Subdivision, Ramgarh Cant, alleging that one Rajkumar Shashi, posted as assistant at Chittarpur Police Post Office in connivance with Bhola Prasad, Assistant Postmaster of Chittarpur Post Office, fraudulently withdrew rupees 63,745.10 from 2 saving banks account and 1 CTD account on the basis of forged passbook, transfer form and other forged forms. It was also alleged that the said persons acted in connivance with Bhuvneshwar Prasad, within bracket petitioner, and who was the in charge of saving bank branch of Ramgarh Cant Post Office, and withdrew rupees 32,547.70 from Chittarpur saving bank account of one Virender Kumar. The details of the money withdrawn by the accused persons was enclosed with the FIR. On the basis of investigation and materials collected, charge sheet was filed and ultimately the charge was framed on 6/4/1999 under section 409, 420, 467 and 120 capital B. Altogether, 7 witnesses were examined on the side of from the side of the prosecution. And a large number of documents were also exhibited. so far as the petitioner is concerned, the learned court found that Exhibit 3, 3/1 and 3/2 were the three self-written statements submitted by him before the departmental inquiry, and the petitioner did not deny these statements. Rather, in his statement recorded under Section 313 of CRPC, petitioner had admitted that he had written these statements and had submitted to the higher authorities of the postal department. In Exhibit 3, the detailed discussion with regard to the evidence against the petitioner has been considered in paragraph 9 of the judgment, 9, 10. Has been discussed by the learned trial court, particularly in paragraph 9, 10 and 11 of the judgment. From 9 onwards, we have पूरा ही discussion. And ultimately, the petitioner was convicted along with other co-accused persons. The learned for offence under section the learned trial court recorded that before closing the account, the petitioner did not ask for physical presence of the depositors. Rather, he handed over the money to other co-accused persons. The petitioner, along with others, were convicted for offence under section 409, 420, 467, 120B of Indian Penal Code. The appellate court also scrutinized, took up the matter of all the three convicts who had filed different criminal appeals, and so far as the petitioner is concerned, his criminal appeal number was criminal appeal 14 of 2013. The appellate court recorded its finding in para 17 and 18 as follows. The appellate court ultimately upheld the conviction of the petitioner for offence under section 409 of IPC and acquitted the petitioner for offence under section 420, 467 and 120 capital B of IPC. By considering the sentence of the petitioner, the learned appellate court to reduce the sentence by citing reasons in paragraph 19, which is as follows. This court finds that both the courts have considered the materials on record, and ultimately the petitioner has been convicted for offence under section 409 of IPC. The learned appellate court has clearly recognized that when the amounts were fraudulently withdrawn, the appellant, the learned appellate court has given the details of the amount which was withdrawn, which was certainly much more than 32,545, and recorded that when all these amounts were withdrawn by the petitioner, he was posted as sub postmaster and he was the custodian of the amount, and he let withdraw the amount by some scrupulous person from the fake account without getting proper verification. The entire modus operandi has been also discussed by the learned appellate court. Considering the totality of facts and circumstances of this case, this court is of the considered view that the appellate court has already reduced the sentence of the petitioner to a period of 1 year, and the matter relates to defalcation of money in post office and defrauding the public money, and accordingly this court is not inclined to modify the sentence. The petition is hereby dismissed. Communicate.
Item 2, Criminal Division 1450 of 2016, along with item 3.
This petition. I think we have adjourned this matter for a couple of days.
I may be allowed to do this humble prayer. Last night, on the instruction of the client, learned senior advocate Mr. Kashyap has been engaged in this matter to assist this ongoing case. So, Your Lordship, he needs time.
No, it was already indicated that no further adjournment will be granted. The complaint is of the year 2001. How many years have elapsed? Were you born in 2001? Were you born in 2001? आपका डेट ऑफ बर्थ कब का है?
Your Lordship, 1996.
1996. चलिए कम से कम जन्म आपका हो चुका। केस का जन्म 2001 में हुआ। I will not adjourn. Either you argue or I will just. Yes, you tell us what is the matter.
Your Lordship, if a short possible, maybe can I take instruction from the learned senior advocate?
We will not adjourn the matter. There is a clear order that no adjournment will be granted.
Your Lordship, I go down to you, but
So, this was passed on 18/9,
yes, Your Lordship.
and then earlier also I remember that this case was being adjourned from time to time, isn't it? I remember that I have made it very, very clear that on the next date I will not grant. Okay, that's over for the day, 1 o'clock.
Like,
Item 4, Criminal Division 1717 of 2017.
Ladyship against concurrent evidence. In fact, our case was that we were cheated.
Show me something very clearly. There are concrete. So you have to show
First-
something very clearly.
First, I must show what is very, very glaring against me. That's why I use the first expression, concurrent acquittals. Your ladyship, virtually, this is a case where the court has refused to exercise jurisdiction. I am saying so according to my own interpretation. May not be strict or sensu correct. Refused to exercise jurisdiction because, according to the court, it was hit by section 300 CRPC. There was an earlier conviction for bouncing of check. In my instance, there was bouncing of check for which there was conviction. Now I also alleged forgery with respect to which I filed a separate case. And that separate case acquittal has been pronounced on the count that the occurrence is same. The court has. Now forgery is not something which can be tried with 420. The occurrence is not same. Cheating I can understand. Cheating is persuade somebody to give. Because your ladyship, 138 is regardless of forgery or no forgery. 138 is when, may just one sentence. 138 is when I give a check to the victim and there is a presumption. It was given for some legal liability. And there is no honoring the notice. So that's regardless of whether the liability was there or not. Here there is a case where I have also alleged that there was forgery. Therefore, your ladyship may allow me to place that.
Forgery in the check?
No. Forgery with respect to deed. Your ladyship may just see one or two portions which I am very, very keen to show. I'm sorry, the handwriting is so bad in the charge. She may see the judgment. The appellate judgment is at page 66. And if your ladyship may allow me to show page 63 first, which is the trial court, because appellate judgment is not really applied to much of mine. It's simply given stamp of approval. Paragraph 11 onwards of the trial court, page 62. दस्तावेजी साक्ष्य जो बचाव पक्षियों से दाखिल किया है. Ladyship, I am placing the judgment which is against me, but it's required to be placed because the facts are clear. Exhibit A या complaint 95 का निर्णय का सर्टिफाइड कॉपी है. इससे न्यायालय द्वारा अपराधी को धारा 138 इनायत के तहत सजा दिया गया है. This is what I was saying. He's already been convicted. तो इस धारा के अंतर्गत चेक बाउंस के लिए 6 माह का 100 अर्थदंड के रूप में 100 नहीं देने पर 1 वर्ष का 100 प्रावधान दिया गया है. Now
you have been convicted.
No, I was
in 138.
I was victim.
Okay, you were the victim.
I was the victim. I filed 2 cases.
All right.
One for bouncing of check.
That's right.
Paragraph 12. उपरोक्त सभी साक्ष्यों को देखने के बाद यह पता चलता है कि CW1 अपने के गवाही में इस जमीन के बाबत एग्रीमेंट होना और उसी सिलसिले में अभियुक्त को पैसा देना बताते हैं एवं जमीन की रजिस्ट्री ना होने के कारण जब पैसा मांगा तो अभियुक्त द्वारा चेक दिया गया जिसे बैंक में देने पर बाउंस कर गया, जिसके लिए कंप्लेंट 95 केस किया गया था. इसमें अभियुक्त संजय पहले ही सजा काट चुका है. वही अपने आगे की पैरा में कहते हैं कि कंप्लेंट 95 एवं 399 2004 के परिवार पत्र का कथन एक ही तरह का है. वही CW2 अपने परीक्षण में परिवादी का समर्थन करते हुए प्रति परीक्षण में उपस्थित नहीं हुए. अतः C95 में मैंने गवाही दिया जिसमें शैलेश को सजा हुआ है. वही CW3 राधिका प्रसाद है. ये कहती है कि ये कोई भी एग्रीमेंट जमीन के बाबत नहीं है. और राधिका प्रसाद इज द ओनर ऑफ द लैंड.
ये किस पेज में आप पढ़े? 63 पैरा 12
कुछ मिस कर रहे हैं.
उपरोक्त सभी साक्ष्यों को देख.
जी देखने पर पता चलता है.
हाँ,
कि CW1 अपने गवाही में जमीन के बाबत एग्रीमेंट होना और उसी सिलसिले में अभियुक्त को पैसा देना बताते हैं एवं जमीन की रजिस्ट्री न होने के कारण जब पैसा वापस मांगा तो अभियुक्त द्वारा चेक दिया गया जिसे बैंक देने पर बाउंस कर गया, जिसके लिए कंप्लेंट 95 केस किया था, जिसमें अभियुक्त संजय कुमार पहले ही सजा काट चुका है. वही अपने आगे के पैराम करते हैं कि कंप्लेंट 95 एवं 399 का परिवार पत्र का कथन एक ही तरह का है. CW2 अपने परीक्षण में परिवादी का समर्थन करते हुए प्रति परीक्षण के लिए उपस्थित नहीं हुए एवं C95 में मैंने गवाही दिया है जिसमें शैलेश सजा काटा है, वही CW3 राधिका प्रसाद है। राधिका प्रसाद इज द ओनर ऑफ द लैंड, जिनका ज़मीन हमको बेचने के लिए के नाम पर हमको ठगा गया। राधिका प्रसाद सेज कि मैंने कोई एग्रीमेंट, उनका एग्रीमेंट दिखाया गया उस हमको और दिखा करके हमको ठगा गया। ये कहती है कि ये कोई भी एग्रीमेंट ज़मीन के बाबत नहीं किया। मीन्स आई विल जस्ट पॉज हियर फॉर अ मोमेंट। द अक्यूज पर्सन gave an impression upon me that he is having an agreement from the landowner Radhika Prasad, and based on that took money from me to carry out the same, and this was not that. So this not only that check which he gave subsequently got bounced, for which separate case was registered. This agreement is forged, which he had placed before me, saying that Radhika Prasad ka. Radhika Prasad
No,
कहती
I'm
है
not able to get the transaction. You see, you are the complainant in this case. This is a
complainant
complaint
proposed
case.
intending buyer of her land.
You are the intending buyer of land, which is through some Radhika Prasad.
Radhika Prasad is landowner.
Okay. Radhika Prasad is landowner.
She never agreed with the accused. Accused is a broker,
Okay.
land broker virtually.
Accused is land broker. Okay,
He projected a picture before me that he is enjoying an agreement from Radhika Prasad
that's right.
to sell. जो
And
होता
for
है
further sale. And for further sale to you. Who issued the check?
this Sanjay
The accused here.
accused.
Accused is the land broker.
Land broker I am saying.
Okay.
Landowner नहीं था. He said that I am agreement holder, power of attorney holder agreement.
He issued the check to whom?
To me.
You were the buyer.
I was
Then
the
you
buyer.
should have issued check to him.
I was the buyer. हमसे पैसा लिया हुआ था. उस पैसा को वापस
Return करने के लिए.
हमसे पैसा लिया, लैंड ओनर को कभी दिया नहीं.
ठीक है. तो उसने रिटर्न करने के लिए आपको चेक दिया. That check bounced.
That check
You filed 138 case, and ultimately,
convicted.
he got convicted. Very good.
He got convicted. He underwent the sentence. 6 महीना रहा और फिर. Now this is a case with regard to forgery of that agreement by which he showed to me and said कि राधिका प्रसाद ने उनको दिया. Now राधिका प्रसाद has denied this. हमने कोई agreement नहीं किया था. हमने किसी से कभी कोई पैसा नहीं. So that use of forged document is genuine and forgery for the purposes of cheating. With respect to that, this trial took place. And the court says that no, it will be covered by 3 years. So that is what my lord will have to test. And court also says one thing, that Radhika Prasad का है कि नहीं है ये signature expert से check होना चाहिए था, and letter expert से. Radhika Prasad is coming and saying that I have not given.
She would say, because she wants to avoid all transactions.
So I'll just read this portion. This is the relevant portion, whatever may be the outcome. CW वही CW3 राधिका प्रसाद ये कहती है कि कोई भी एग्रीमेंट जमीन के बाबत नहीं किया है एवं इससे संबंधित पैसा किसी से नहीं लिया है एवं एग्रीमेंट देखने पर कहती है कि दोनों पृष्ठ पर हस्ताक्षर राधिका देवी जो लिया गया वो मेरा नहीं है. सो सिग्नेचर हैज बीन प्रूव्ड टू बी नॉट ऑफ हर. अपने प्रति परीक्षण कहती है कि अभियुक्त गण का मकान मेरे मकान के बगल में बना है, मैं उनके मोहल्ला के नाते पहचानती हूँ. स्टाम्प पेपर राधिका देवी के नाम से खरीदा गया. वो किया गया था कि उसका ज़मीन दिखा करके हम लोगों को ठग करके राधिका देवी का ज़मीन का एग्रीमेंट कर. और उसके बाद नहीं हुआ ट्रांजेक्शन. वही एकरारनामा है जो दिनांक 1/1/2003 को बनाया गया है, जिसमें विक्रेता के रूप में राधिका देवी का हस्ताक्षर है, जिसे राधिका देवी अपना नहीं बताती. इससे गवाह के रूप में शैलेश कुमार का भी हस्ताक्षर है. वो जो ब्रोकर था ही पोर्ट्रेड हिमसेल्फ एज गवाह इन दैट एग्रीमेंट हमारे पास. किंतु इस एकरारनामा को देखने पर यह स्पष्ट नहीं होता, नो द फाइंडिंग इज कमिंग ऑन दिस. यह स्पष्ट नहीं होता है कि यदि यह हस्ताक्षर राधिका देवी ने नहीं किया है तो अभियुक्त कैसे उनका हस्ताक्षर किया. और दिस इज इरेशनल एन अप्रिसिएशन. आई वेरी रिस्पेक्टफुली से किसी हैंडराइटिंग एक्सपर्ट से इसकी जांच नहीं कराएगा. वही इस एकरारनामा के अन्य गवाह का भी हस्ताक्षर है एवं इस एकरारनामा में टंकन करने वाला हस्ताक्षर उनकी गवाही इस केस में होनी चाहिए, जो कि नहीं भी बताते कि एकरारनामा को किसने तैयार करवाया. वही स्टाम्प पेपर में राधिका देवी के नाम से खरीदा गया, जबकि स्टाम्प पेपर वेंडर को बुलाया जाता तो स्पष्ट हो सकता था कि ये पेपर किसने खरीदा, जब पूर्ण रूप से स्पष्ट नहीं। अब क्या होता है, कोई पहचानेगा नहीं कि कौन स्टाम्प पेपर खरीद रही है, जिसके नाम से लिया जाता है वो नाम से वो इशू कर देता है। Now it
Why
will
did
only
you
be the,
take any step for signature examination of Radhika?
that was not done.
That is quick.
Because Radhika himself came and said, मेरा signature नहीं है.
That is not sufficient.
If your lordship is, ladyship is of that view, then I'm out. But my contention is,
You should have insisted that it is
if
her
defense
signature
was,
and then it
your
should
ladyship,
be.
my respectful submission, if defense was taking this defense, the defense ought to have done this. I have discharged my onus by adducing evidence of Radhika, who comes and says that it's not mine. Now the onus shifts. Now it shifts on the accused. So the defense should have done this. And the failure of defense should raise an adverse inference against him because he knew that if he goes for this, evidence will be against him. So adverse inference should be drawn against defense. Once onus has shifted. If your ladyship feels that onus has not shifted, then I'm out. इस गवाह में इकरारनामा के अलावा जितने भी दस्तावेजी साक्ष्य सभी स्वयं में प्रयोग किया जा चुका है, उसका निर्णय भी एग्जीक्यूट हो चुका है, उस पर कोई डिस्प्यूट नहीं है कि उसको चेक बाउंसिंग में हुआ सजा.
And this
next page.
particular document was an exhibit in check bouncing also. Must have been.
Must have been.
Must have been.
Although it is not required.
No, because if the liability is being denied, then certainly it is required. If the liability is completely denied by on the touchstone of preponderance of probability, then it might have been exhibited.
The liability is presumed under 138.
Not, but
for the defense, it is for the defense to.
No, it is not a conclusive proof. There is not a conclusive presumption.
That's there, but your ladyship, with regard to liability in respect of check bounds, this document is not required to be proved.
We do not know what all documents had come at that point of time.
The documents that has been discussed, but that document is regardless whether it was forged or not. If a check has been given to me for money which has been taken, your ladyship, what happens? Either the document was forged or it was not forged. In either case, if he has taken money from me and not doing the sale deed to me, let's assume that the document was genuine and he is not doing sale deed to me. He is supposed to give back the money. As against that, he gave a check. That check got bounced. There is bound to be liability under check bouncing law, and that is what has happened. He has been convicted. So that's regardless of this document being forged or not forged. Therefore, forgery of this document was never an issue in check bouncing case. Still, the learned court of magistrate, the first court, holds at page 65, second para. इस तरह दोनों वादों में एक ही घटना है, वो विषय वस्तु का जिक्र है. I dispute this respectfully. विषय वस्तु एक नहीं है. The deed is an incidental fact. The agreement is an incidental fact. Its genuineness or ingenuineness is absolutely irrelevant with respect to check bouncing case. सारे दस्तावेज भी दोनों वादों में एक ही हैं. That's correct appreciation. अतः यह धारा 300 के अंतर्गत आता है. कृष्णलाल यादव विरुद्ध कोई साक्षी नहीं. I am not disputing that. Although we have challenged that. परिवादी, क्योंकि कृष्णलाल यादव has not forged the document. संजय has forged the document and used it. परिवादी अपने केस में कुछ जरूरी साक्ष्य जैसे स्वयं करने में असमर्थ है. उसको जालसाजी हुई तो सिद्ध बात करने में साक्ष्य नहीं हुआ. तो there is one finding of fact and one finding of law. Finding of law is with regard to section 300. Applicability of 300 is what your lordship may decide, and finding of fact is with regard to the document being genuine or not genuine. My respectful submission is, so far as finding of fact is concerned, I am conscious of the fact that I am in revision against acquittal. What to talk of revision even in appeal, if there is an acquittal, and I want the court to take a different view than the original court, I must show that there has been perversity, irrationality, etc. That I am trying to show by virtue of the fact that in the judgment itself, the original court has said certain things which I read out. That's not correct. That's not correct appreciation. It's not just that there were two views possible which he has taken, one out of which one he has taken. Once I have adduced evidence of the purported signatory who has come and said that I have not signed it, the burden shifts upon the person who is challenging this. The law relating to burden of proof is substantive. Then comes the appellate judgment in addition. Appellate judgment has appreciated at page 70, CW3 Radhika Prasad is the owner of the land, denied execution of agreement. In addition, we come to page 70.
You read from CW3.
Yes, page 70. CW3 Radhika Prasad is the owner of the land, purported to be sold out, denied execution of any agreement deed for sale of the land and also her signature on exhibit 1. She also denied to receive any consideration amount from accused Shailesh Kumar for the same. She identified the accused person. In cross-examination, she denied any negotiation with Krishna Lal Yadav for purchase of Katal. Krishna Lal Yadav was the father of Shailesh. She could not say as to from whom the land was obtained. She denied signature of accused persons on agreement deed before her. She also denied signature of Krishna Lal Yadav on the agreement deed. She admitted that accused persons have been residing outside her house. She denied any agreement between herself and Sanjay. On the other hand, accused number 1, Shailesh, stepped in the witness box as DW1. Shailesh Kumar admitted filing of 2 cases by the complainant for bouncing of check. He also admitted his conviction of 6 months, a fine of so and so. Further stated the complainant filed a criminal provision against the judgment which was dismissed. Complainant also filed money suit which was also dismissed. He further stated to pay rupees 3,54,000 to the complainant, but he has not got any receipt. In cross-examination, he admitted to undergo punishment for default of payment from non-payment of check. The perusal of record reveals that the complainant himself, CW3, also has not supported any signature of Krishna Lal Yadav on the agreement deed. CW1 has also not supported signature of Krishna Lal Yadav on the agreement deed, rather denied signature of accused person before her. Perusal of record, it appears that there is no material at all against the accused Krishna Lal Yadav. Perusal of record further reveals that signature of purported landlady Radhika Prasad has not been properly proved by the complainant. Now this is incorrect. No law of evidence says that this kind of proof is improper. It's not inadmissible evidence, nor it has been admitted by violating any procedure. There is no irregularity in this. It has not been properly proved. Though the complainant herself denied her signature on the agreement deed, but the complainant has not got it compared with the original signature said Radhika Prasad scientifically by the expert and writing expert. More so, basically, this is the case of non-payment of check amount and also false impersonation of Radhika Prasad. Admittedly, complainant has filed 2 cases bearing complaint so and so for the same offence and same occurrence. This is incorrect. It's not for the same offence. It's not for the same occurrence. Forgery of deed is a separate offence. Why I say so, Your Ladyship? Had it been cheating, then matter would have been different. It is distinguishable. Check bouncing liability will be regardless of deed being forged or not forged. It is a special protection to a victim of check bouncing, that whenever there is a liability, first of all, the liability is presumed, and if the liability is there in monetary terms, check has been given, offence is made. Why this check was given, why the money had passed on, whether the foundation of passing of the money was genuine or ingenuine, that's regardless. That's completely a separate transaction. The learned court has relied upon Your Ladyship at page 72, Your Ladyship find Kollavira, which is a judgment relating to 420. Because 420 is same transaction. A says something to B, persuaded by that B gives money to A, and then refuses to give back. 420 can be made out, 138 can be made out, by the same facts, same occurrence. But whether giving and taking of money was based on, it was founded on a deed which was forged or not forged, is regardless. That has to be a separate transaction. That's my humble submission.
What do you have to say?
The Radhika Prasad is the landlord manner, and is not a signature in the agreement manner.
He is appearing state or
May notice to opposite party number Krishna.
She has refused to appear. He has refused to appear. The notice is served. Opposite party, the record reveals that opposite party number 2 has received the notice himself, and the notice upon opposite party number 3 has been served through his son. Simple. Order भी upload हुआ 22/8/2024. क्या बोलना है आपको बताइए.
complainant sir denied the signature of the agreement, but the complainant has not got the compared with original signature, said Radhika Prasad. A scientifically very expert and written history expert. Basically, the case of non-payment of the check amount and also false impression of the aforesaid Radhika Devi admittedly complaint is filed for the two cases value. The complaint case number 5 of the 2004 and the 399 of the 2004. Complaint case number 95 of the 2004. The accused respondent has held the guilty and the sentences under the SI for 6 months and fine of rupees 3,54,000 under 6 months. This has been also taken when the complaint petition the allegation of against the accused persons.
I'm not able to understand what are your arguments. Yes.
प्रॉपर पढ़ती नहीं है
Sorry?
तैयारी करती
तो इतना देर से क्यों सुन रहे हैं? You never say that you are not ready with the case. You waste 15 minutes of court time.
तो आर्गुमेंट करने तो बीच में इंटरफेयर नहीं करना
बहुत अच्छी बात है. और कोर्ट का टाइम ऐसे वेस्ट करने के लिए
इसको कल पढ़ देते
नहीं रखेंगे.
तो सेकंड हाफ टाइम इसको
सेकेंड हाफ में बेंच है.
दो केस के लिए पास में
सॉरी,
दो केस के लिए पास में करना पड़ता है
करी दो ही केस 40-1 आ जाए. इससे ज़्यादा तो आप घर पे भी नहीं पढ़ेंगे. पढ़िए. कोर्ट के अंदर ज़्यादा दिमाग का चलता है. Efficiency is to the
इसको
maximum.
नेक्स्ट
when you are
वीक
in
में
the-
रखते हैं
No, you have wasted 15 minutes. I will not
वो
enjoy
हम
it.
ये आर्गुमेंट कर रहे थे तो बीच में इंटरफेयर नहीं किए
नहीं, आपको you don't understand. There are so many people waiting for their cases to be taken up. You waste 15 minutes of court time.
सॉरी ब्रदर
You say sorry to yourself and read the brief. 15 मिनट में. जो चीज़ 15 मिनट में नहीं समझ आएगा वो 15 दिन में भी समझ आने वाला नहीं है. एकदम सीधा साधा केस है. पढ़िए. चलिए नेक्स्ट केस.
Secretary, may I take leave?
I'll hear him and pass the order.
Yes, I try to be here in case some cases got out.
दो केसेस और भी
Item 5, Criminal Justice 7 of 2018.
Yes, petition.
The husband 498 years sentence. Though the earlier the matter was referred to the Jhalsa, the matter was compromised in some terms, but that terms has not been effected till date.
Yes.
Yes,
That's the husband.
yes, madam. Petitioner is the husband.
I think
Madam. As per the allegation of the informant has filed a complaint which turned to the affair, where it is alleged that the marriage of the informant and the petitioner was taken place on 12/3/99, and the marriage, some cash amount and some other articles were also given. It is subsequent to marriage, there is a demand of rupees 2 lakh from the informant by the petitioner and other co-accusers or in-laws, and she was subjected to torture and assault, etc. And that lordship she was driven out and the case was filed.
when was she driven out?
Lordship says that on 28/1/2001, he says that 28/1/2001, Her father went on that day, and on that day she was taken by her father. Though there is a series of litigations between the parties on divorce suit was also filed by the petitioner.
When?
That divorce suit was ultimately dismissed as a not maintainable by the full judgment. Though the plea was taken by the petitioner that since he had earlier filed the divorce suit, therefore on retaliation this petition was filed. However, I am not going to that part. So for the evidence of the informant is concerned, also see PW1. And the discussions made in paragraph 14 of the judgment of the appellate court judgment in paragraph 14. That namely summarize the agreed informant herself in this case. She has stated in her joint chief that she was married with Uttam Rai, that is the present appellant on and
You read para 14, please.
my lord?
Para 14, please.
Yes,
It appears.
Oh, it appears that the present appellant was convicted and sentenced for the offence under section 498 of the Indian Penal Code on the basis of the prosecution evidences on the record. The prosecution has got its 8 witnesses examined in this case in order to substantiate the charge against the present appellant, among whom PW1 namely summarized the agreed informant herself of this case. She has stated in her examination in chief that she was married to Uttam Rai, that is the present appellant, on 12/3/99 as per a Hindu custom, where after she went to Ramgarh with her husband who was working at Chairperson. She has further stated that she remained properly at Ramgarh for a period of 2 months. Thereafter, her husband brought her to Chairperson on 26th of January and they were living in the house of Shobha Mishra at Chairperson. She has further stated that she remained properly there for 2 years only after her husband started demanding ₹2 lakh, telling her to bring that amount from her father. She has further stated that when she demanded the money from her father declined to give money. Thereafter, her husband started beating her for even on the saying of the accusation. So, Mr. These witnesses further stated that her husband was doing anything upon the saying of Shobha Mishra, and her husband, along with the said Shobha Mishra, even tried to set her ablaze to the gas. Thereafter, she called her brother, namely Santosh Mehta, who came to Chairperson and brought her at Kandla, where she remained for 1 week. Thereafter, her father-in-law brought her to Ramgarh, where her mother-in-law, father-in-law, Jetani Devar, started beating up her, demanding ₹2 lakh from her. She has further stated that her father came to pacify the situation, but her mother-in-law came as her ornament with her. She has further stated that her husband came to Ramgarh on 13/1/2000 and beat up her. At last, her father came to 28/1/2000 and brought her to Kandla, so where she was medically treated. Also, she has further stated that her father requested the accused person to take her back, but her husband did not become ready to. She has further stated that her husband came in the marriage of her sister Kandla on 9/5/2000 and told her that he shall not take away her unless until he pays money. She has further stated that the panchayati was also held in the matter of Ramgarh, but the accused person did not made their way. The witness has identified a proof of conviction upon initially filed complaint petition, and the same have been marked as exhibit number 1, 2, 3. It appears from the evidence of the witness are intact in her course examination, also is not shattered in any way.
So all the persons were convicted, or you were only convicted?
My lord, no, other in-laws have been acquitted by the trial court itself. So only the husband is convicted.
So what is your argument?
My lord. My argument is also that when she was subjected to, when she was tested in cross-examination, she has stated that I am reading this some paragraphs of the cross-examination, not.
No, what do you want to say?
I want to say that prior to this complaint, she used to write some letters to her mother-in-law and other relatives. Who those letters have been exhibited. And in those letters, some other matters have been written, but she has not written in any of the letter that she was subjected to torture by.
चलेगा आपका ऐसा बहस?
नहीं, जो है fact
She
जो है.
has in her evidence, she has fully supported her case, isn't it? There are witnesses also regarding demand.
That is there. What the plea taken by the petitioner from the very beginning from the very trial court to the appellate court, that I have seen. However, Lordship, the alternative.
These documents have been considered by the appellate court.
Yes, those documents
It
have
is
been.
not a case that it has not been considered.
No, those have been considered. That
Merely because she has not stated so in the letter, that
That
cannot be a
cannot
ground for acquittal, isn't it? That is
But-
only one of the evidence.
Lordship, to cut short the matter, Lordship, the one only alternative argument I have seen the entire evidences of the witnesses, that the matter relates to year 1999 and the conviction under sentence is 3 years. And so far the custody of the petitioner is concerned. On 26/5/2007, he was surrendered before the court and the bailed out by the learned CGM itself on 29/5/2007 in 3 days. And now at the time of the revision, 4/5/18 to 26/6/18.
Maximum you can say about 2 months.
Maximum is about 2 months. And at the time of the judgment,
Not 2 months, 5 and 6.
My lord,
Less than 2 months.
yes, just almost 2 months.
Yes. That's all. Okay.
Direct allegation against the husband.
Direct allegation है इसीलिए conviction. Sentence पे बोलो.
Demanding dowry, torture, physical, mental.
कोई मेडिकल रिपोर्ट एग्जिबिट हुआ?
मैंने मेडिकल रिपोर्ट तो कहीं से कोई एग्जीक्यूट नहीं दिखा था.
अब आपसे हम सवाल ही नहीं पूछ रहे.
अच्छा, ठीक है.
बताइए कोई मेडिकल रिपोर्ट एग्जिबिट हुआ?
नहीं.
सेंटेंस में कुछ बोलेंगे? कुछ नहीं बोलेंगे. बताइए.
Sentence rightly दोनों कोर्ट बोथ कोर्ट
डिवोर्स हुआ है कि नहीं?
है.
डिवोर्स हुआ है?
नहीं, डिवोर्स केस फाइल हुआ था जो डिसमिस हुआ.
Who filed the divorce case?
हस्बैंड.
That has been dismissed. And you are living separately. You are living separately.
Both party is separately.
Any child? No child.
और जो मीडिएशन रिपोर्ट में था उसमें हम किसी तरह का एलॉमनी वगैरह में डिमांड है, क्योंकि हम इनके साथ जो प्रीवियस एक्ट इनका था उसके चलते हम इनके साथ रहना भी नहीं चाहेंगे और बस कोई हम डिमांड भी इनको नहीं करें, जो कि मीडिएशन रिपोर्ट में ये चीज़ है.
You have simply broken off with the petitioner.
क्योंकि जिंदा रहना है तो छुटकारा है.
ये 99 का मैटर में 3 साल का कन्विक्शन कहाँ तक मैक्सिमम है? मैक्सिमम. टॉर्चर के जो और एक्सट्रीम केसेस होते हैं 498 में, उसमें तो 3 साल समझ आता है. क्या वैसा एक्सट्रीम केस है? ठीक है, लाइफ तो वी कैन अंडरस्टैंड. लाइफ इज मोर वैल्यूएबल देन एनीथिंग एल्स. बट so far as the element of torture is concerned,
टॉर्चर तो
टॉर्चर तो हुआ ही है तभी कन्विक्शन.
हाँ, टॉर्चर तो हुआ है.
डिमांड होने से कन्विक्शन हो जाता है. डिमांड होने से घर से निकाल दिया काफी है.
मिलॉर्ड सबसे इम्पोर्टेंट
हैरेसमेंट होने से
नहीं, सबसे इम्पोर्टेंट चीज मिलॉर्ड कि कोई भी लड़की चाहे कोई भी वुमन नहीं चाहेगी अपना परिवार.
आपकी बात सही है.
99 में शादी हुई है।
एक्यूटल का बात ही नहीं कर रहे हैं,
नहीं, हम-
सेंटेंस का बात कर रहे हैं।
क्योंकि 12
3 साल इसको दिया है, कितना साल हो गया? 25 साल हो जाएगा, राइट? साथ में रह भी नहीं पा रहे हैं,
नहीं,
तो सेंटेंस तो मॉडिफाई करना है, क्या करें बताइए?
हम उसमें ऑब्जेक्शन नहीं करेंगे, क्योंकि
फाइन अमाउंट कितना होना चाहिए?
फाइन अमाउंट तो कुछ
2 लाख रुपए मांगा था, 2 लाख रुपए फाइन कर देते। लो मनी कहाँ से आता है? आप
Yes.
बताइए।
हमको कोई उसमें ऑब्जेक्शन नहीं,
मेंटेनेंस वगैरह कुछ पाई की?
कुछ नहीं। हम इसीलिए वो चीज को आपको मेडिसिन रिपोर्ट एक बार हम पढ़ दे रहे हैं हम लोग।
नहीं, मीडिएशन रिपोर्ट पढ़ के हम लोग केस नहीं डिसाइड कर।
नहीं नहीं, हम डिसाइड की नहीं है, लड़की इस तरह से मतलब कि हुई है कि वो नहीं कुछ लेना तक नहीं चाह रही। विपक्षी सोमा राय आवेदक उत्तम राय,
Her life is, her life is ruined. Therefore, she is absolutely not able to settle it with money. That is there, but money is also important in life. May not be of much importance to her. That is important.
Yes.
If she wants to take the fine amount, she will take it. If she doesn't want to take the fine amount, she'll say that I don't want to take it. ठीक है? डिस्क्रिशन है उनका, डिस्क्रिशन है उनका, ठीक? How the learned counsel for the parties. This revision has been filed against judgment. Dated 18/1/2018, passed in criminal appeal number 79 of 2012 by learned district and additional sessions judge Roman 3 Saraikela Kharsava, whereby the appeal filed by the petitioner has been dismissed. The petitioner has been convicted 99 का मैटर आप बोल रहे हैं?
जी 99 बोलिए।
FIR कब का है?
FIR 2005, डेट ऑफ मैरिज
99 डेट ऑफ मैरिज।
FIR 2005 का ही है।
हाँ FIR 2005।
The petitioner has been convicted in a case arising out of GR case number 550 of 2005 / TR number 79 of 2012, arising out of Gamharia PS case number 70 of 2005 by the learned sub-divisional judicial magistrate Saraikela for offence under section 498 capital A of IPC, and has been sentenced to undergo rigorous imprisonment for a period of 3 years होगा ना?
हाँ 3 months हम बाद में शुरू कर देते
3 years and fine of rupees 5,000 with default sentence. The learned counsel appearing on behalf of the petitioner while assailing the impugned judgment has submitted that though there are concurrent findings recorded by both the courts with respect to the petitioner, but the learned court has not considered the relevant documentary evidence which was produced, has not properly considered the documentary evidence which was produced, which were the letters issued by the informant लेटर पढ़िए, पेज 34।
तो ये माँ जी हमको ऐसा लग रहा है कि मेरे साथ भगवान भी नाराज हुए, किस कारण है मुझे नहीं मालूम है। पहले मेरा रुपया गया, दूसरा बार मेरा जेवर गया, अब लगता है मेरी बारी है। जिस तरह से जेवर गया हमको कुछ पता नहीं चला, उसी तरह से मेरी जान भी लगता है चली जाएगा।
The learned counsel for the petitioner has submitted that in the letter written by the informant, no allegation of torture was reflected. He submits that the impugned judgments call for interference. The learned counsel further submits that without prejudice to their aforesaid submissions, he has also argued on the point of sentence and has submitted that the FIR is of the year 2005 and more than 14 years has elapsed. The petitioner has remained in custody for a period from 26/5/2007 and released on 29/5/2007, and thereafter at the stage of revision from 4/5/2018 to 26/6/2018, which is more than 1.5 months. He submits that as per the allegation, there was a demand of ₹2 lakhs by the petitioner, and after the marriage on 12/3/99, and the informant was driven out from her matrimonial home on 28/1/2001. He submits that the petitioner and the informant are living separately since 28/1/2001, correct? Though the FIR was registered only in the year 2005. The learned counsel appearing on behalf of the opposite party number 2 has opposed the prayer and has submitted that there are concurrent findings recorded by both the courts, and neither the sentence nor the conviction calls for any interference. State, क्या बोलना है?
पेज 29 में आया है, इसको गैस से भी जलाने का प्रयास किया गया।
The learned counsel appealing on behalf of the state has also submitted that it has been alleged by the informant that an attempt was made to burn her by cooking gas. After hearing the learned counsel for the parties and considering this court finds that the prosecution case is that initially a complaint was filed, being C1 case number 42 of 2005 by the informant, stating that her marriage was solemnized on 12/3/1999 and with the petitioner. The complainant stated that the husband was residing at Chaibasa working on daily wages in the office of Deputy Commissioner, who used to go to Ramgarh also. Her father had given 1.25 lakhs in cash and other materials at the time of marriage. And when she was taken to Ramgarh after her marriage, she was properly treated for 1.5 months. Thereafter, she was taken to Chaibasa by her husband on 26/5/1999, and both of them, they started residing in the house of one Sobha Mishra on rent. Her further grievance was that the petitioner had assured her to get her admitted in PT course, but he started torturing her just after 2 to 3 days, and she found her husband in an intimate terms with aforesaid Shobha Mishra. She further alleged that her husband had asked her to bring rupees 2 lakhs from her father, and thereafter he became violent and started assaulting her mercilessly on refusal. She has further alleged that her husband even went to set her on fire through gas cylinder in connivance with Shobha Mishra. However, she could save herself. She has stated that her brother came to Chaibasa after getting the information and took her to Ramgarh. She has also alleged that her in-laws started torturing her for not bringing these 2 lakhs from her father and threatening her to kill and to get her husband married with some other girl if she did not bring rupees 2,000. She has further stated that on account of non-fulfillment of demand, she was tortured, and when she went to her in-laws' house on 2 to 4 occasions, she was sent back. Initially, the case was filed as a complaint case, and ultimately the matter was sent for investigation under section 156(3) of CRPC, which was registered as Gamaria PS case number 70 of 2005, dated 8/5/2005, for offence under section 40498 capital A, 406, 32 and 34 of IPC. The petitioner, along with other co-accused, all her family members, were charged for offence under section 498 capital A/34, 406/34 and 323/341 of IPC. The trial court, at the stage of trial, the informant was examined as PW1. Altogether, 8 witnesses were examined from the side of the informant. ये लीजिएगा पैरा 4 और 6 से the details. No defense evidence.
Oh, so certain letters would
No defense witness as such was produced, but 3 letters were exhibited. 2 letters were exhibited as Exhibit A and A. The learned trial court scrutinized the materials on record and recorded the findings in paragraph 19 onwards. After scrutinizing the materials all on record, the learned court ultimately held that the allegation of torture made by the informant regarding her demand regarding demand by her husband at Kandra in Ramgarh as well as in Chaibasa could not be falsified by the defense. And recorded a finding that the evidences on record it appeared that the informant was being tortured by her husband for fulfillment of demand, and there was no ambiguity on this point in the evidence of the informant. And the witnesses have also corroborated the evidence to some extent. The learned court recorded that the offence under section 406(34) and 323/34 of IPC was not proved against all the accused persons, and the prosecution was able to prove offence under section 498 capital A IPC against the petitioner, the husband, beyond all reasonable doubt. The learned court ultimately also acquitted all other accused persons for offence under section 498 capital A of IPC. The learned court sentenced the petitioner for 3 years rigorous imprisonment with fine amount of ₹5,000 under section 498 capital A. The learned court has also taken into consideration the letters which was produced by the petitioner exhibit A and A by 1. The appellate court has also considered the materials on record, and with regard to the letters sent by the informant, the discussion is at para number 23 of the appellate court judgment, which is quoted as under. The appellate court has recorded that the letters revealed that the informant had faced some sorrow, and even if the letter did not mention about demand of dowry and torture to the informant, the same will not mitigate the offence, as the prosecution witnesses have fully supported the mental as well as physical torture of the informant of the case, and non-mentioning of torture in the letters was not fatal to the prosecution case. The learned court ultimately upheld the conviction of the petitioner and recorded the finding in para 24 as follows. The learned appellate court also recorded that the sentence passed was also proper. The appellate court judgment was passed on 18/1/2018. This court finds that both the courts have duly considered the materials on record and have convicted the petitioner for offence under section 498 capital A of IPC. Even the letters which were pointed out by the learned counsel for the petitioner, that is Exhibit A and A by 1, have also been duly considered by the courts. In view of the aforesaid facts and circumstances, this court finds no illegality or perversity in the impugned judgments convicting the petitioner for offence under section 498 capital A of IPC. The basic ingredients for the offence having been duly satisfied based on materials on record. The conviction of the petitioner is accordingly upheld. So far as the sentence is concerned, this court finds that the petitioner has been given the maximum sentence of 3 years rigorous imprisonment. 3 साल है ना maximum? With fine of rupees 500. The appellate court was of the view that the sentence did not warrant any interference. However, the appellate court, however, this court is of the view that the FIR is of the year 2005 and the informant was ultimately driven out of a matrimonial home on 28/1/2001. And the petitioner has faced a criminal case for a long time. Absconder नहीं ना रहे हैं?
नहीं
हाँ?
नहीं रेस्पॉन्डर का तो नहीं, हम तो देखे रिकॉर्ड करके थे.
Considering the totality of facts and circumstances of this case, this court is of the view that the sentence of the petitioner is required to be modified to some extent in order to meet the ends of justice, and some fine amount be imposed which can be remitted to the informant of the case by way of victim compensation. Accordingly, the sentence of the petitioner is hereby modified and reduced to 1.5 years rigorous imprisonment with fine amount of rupees 2 lakhs to be deposited by the petitioner before the learned court within a period of 2 months from the date of communication of this judgment. If the fine amount is not deposited within the stipulated time, the petitioner will serve the sentence as awarded by the learned court. The fine amount be remitted to the informant of the case after due quality.
सेंटेंस वाला पार्ट को छोड़ दिया, जो फाइन अमाउंट भी रख दिया, जैसे फाइन अमाउंट
पैसा नहीं देंगे तो आराम से जेल में।
नहीं तो फिर 1.5 साल उधर किया गया, 2 लाख रुपया भी किया गया था.
कोई बात नहीं, अगर नहीं है मन है देने का तो मत दीजिए।
तो फिर
डिफॉल्ट क्लॉज है ये।
1.5 साल तो रह गया, उधर 1.5 साल तो नहीं रहा.
1.5 साल कहाँ रह गया? 1.5 महीना रह गया।
नहीं 1.5 साल यूज कर रहा है, बोलते हैं कि 1.5 ईयर्स उसको कर दिया गया 3 साल से.
हाँ तो आधा कर दिए ना।
2 लाख वाला रहना चाहिए उसको.
Period undergone. Not a case for period undergone. This is a continuing torture to the wife. अगर आप 498A को देखें तो उसका लाइफ तो बर्बाद ही हो गया।
इनका भी तो ही हाल है.
जो सेकंड शोभा जी के साथ तो रही है.
कोई बात नहीं, थोड़ा सा वैसे भी आपको he is entitled to some maintenance, isn't it? इसीलिए 2 लाख रुपए दीजिए और अपना सेंटेंस थोड़ा सा कम रखिए। पास ओवर है उनका 12 बजे, आपका
1 बजे फिक्स।
1 बजे तो 1 ही बजे होगा। 1 बज गया क्या? टाइम पे पता ही नहीं चलता। इनका फिक्स मैटर पहले करिए, पहले से 1 बजे के लिए फिक्स्ड। ये अपने केस का टाइमलाइन सही से बताएं.
Item 6, criminal case 7C0 of 2020.
That I had also given in the very short timeline.
Ah.
1995 में the petitioner and the respondent got married.
1995. They got
Right.
married.
Decree of divorce between the petitioner and the ex-husband was passed in on 29/1/1999.
29/1/1999.
Then thereafter the petitioner and the respondent lived as husband and wife for a period of further 13 years
Till
till 2012. And then on 10/4/2018, the petitioner preferred original suit 170 of 2018 for maintenance.
10/4.
2018. One more thing I would like to point out, my lady, that the TMS case which was filed and which was decreed on 29/1/1999, it was filed under section 11, which is a provision of nullity.
It entered
Then-
into mutual consent.
Then it entered into mutual consent, but just
You will not
just
see. You will
just
see
I'm
only
pointing
the.
this
I have seen that.
and
वो mutual consent हो गया और गलती हो गया.
because just to save the time ये किया गया था और एक जो पिछला बार जजमेंट हम प्लेस किए थे उसका पैरा 11 एक बार नहीं कर पाए थे उसको बस कर दे रहे हैं.
उसमें कोई concrete proof या refusal concrete proof of marriage का कोई date है कि नहीं जो आप judgment प्लेस करें.
जजमेंट जो प्लेस कर रहे हैं उसमें
उसमें जैसे कि here there is a clear evidence that the marriage has taken place prior to
Yes.
divorce.
but
What was the situation in that case which you were saying? Where is that judgment?
लाइव लॉ का माइंड
कहाँ चला जाता है? ये इसी में. पढ़िए जरा.
इसमें जो एनालिटिक्स पार्ट है वो हम बाय रेडी को पॉइंट आउट कर दे रहे हैं कि पैरा 3.2 ही एनालिटिक्स कर देता है. सुबेदार भावे expired in the year 2001. Thereafter, appellant number 1 approached the respondent for family pension. The said request was, however, rejected by the respondents on the ground that deceased had got divorced in November 1990, whereas the appellant number 1 claimed to have got married him in February 1981 during the subsistence of the marriage. Same analogous to it. And इसी में पैरा 11 पिछला बार नहीं प्लेस कर पाए थे.
This was arising out of what? Matrimonial suit or what was
It is a service matter.
Service matter.
तो लेकिन इसमें जो पैरा 11 है that is very important. Para 11 says that it is no longer res integra that if a man and woman cohabit as husband and wife for a long duration, one can draw a presumption in their favor that they were living together as a consequence of a valid marriage. The presumption can be drawn under section 114 of the Evidence Act. Further, my lady, in one more judgment I would like to place that it was upon the respondent to null that presumption. Justice Krishna here has given this judgment. Only 2-page judgment.
भैया आप सुप्रीम कोर्ट के जज का नाम ले रहे हैं. आप कैसे नाम लेते हैं?
I'm
Honorable.
honorable.
He's a legendary.
I'm so sorry.
He's a legendary judge, isn't it?
Yes, that's why I pointed out his name, but I forgot to.
वैसे भी सुप्रीम कोर्ट का जजमेंट है, नाम लेके बोलने की कोई
My
रिक्वायरमेंट.
apologies.
Every judgment is binding on us.
What इसमें just the order part on the first page. For around 50 years, a man and a woman, as the facts of this case unfold, lived as husband and wife. An adventurous challenge to the factum of marriage between the two by the petitioner in this SLP has been negatived by the High Court. A strong presumption arises in favor of the wedlock, where the partners have lived together for a long spell as husband and wife. Although the presumption is rebuttable, a heavy burden lies on him who seeks to deprive the relationship hardship of legal action. So it was for the respondents therein to prove that there was no cohabitation or no relationship in the nature of marriage, as in the incident case, which has not been done so. And once more, I would
the
like to.
condition precedent for getting a maintenance is that the wife should be a legally wedded wife. If two persons are cohabiting together for a very long time, then there can be no doubt that a presumption of marriage will be drawn. But in your case, you yourself have taken a plea, or it stood proof that the marriage had taken place in 1995 during the subsistence of the first marriage. So your marriage, though annulled, initial marriage though annulled later on, but on the day you had married, on that day your marriage was not valid. So you want to say that you acquired the status of the wife by virtue of subsequent period during which you had lived with him.
Yes, ma'am.
And you have been living in his quarter only. It has come on record.
Yes, ma'am.
This is
Living
your case.
in his quarter and Exhibit 3, that is the joint passport. उसमें भी दोनों का साथ में photographs है. Then
You have always been projected as
a wife.
As a wife.
And
To the society at large.
And one more coordinate bench का एक judgment और place किए थे. उसमें है कि strict proof of marriage is not required. अगर जैसे हम 2000 जब decree of divorce हुआ उसके बाद हम फिर से शादी
That's right. At the stage of maintenance, strict proof of marriage is not required.
This had been filed for maintenance only.
That's right. So.
And there is one more Supreme Court judgment. उसमें लेकिन है कि just excuse me for a moment. उसमें my lady है कि Supreme Court का है कि there are certain guidelines which have to be seen कि nature of relationship when it can be termed as marriage. This being a very voluminous judgment, I could not take the.
What is the name of the party?
That has been dealt in this judgment. The name was Indra Sharma versus VKV Sharma.
Which paragraph are you referring to?
That one which is flat, 56, para 56.
Now you see, you have another fact situation over here.
Yes, this is a domestic violence case.
That's right. Domestic violence is not limited to wife.
Yes.
But you have another fact situation here, that it is your case that you have lived with the opposite party lastly 24/11/2000.
Yes, ma'am.
And you have filed your case on 10/4/2018.
But that was for
So-
the trial court to point out.
No, need not.
My only prayer would be that.
Therefore, this gap, you see, there is a period when you are living together and then you discontinue. So you are entitled to some protection of law as long as you are living together. Because the very basis of your marriage in 1995 is void. So this gap is equally important to see. You have left him, and then it is not your case, you were thrown out. That is not your case.
I did, but I'm just not in touch with the client because why this gap has created.
Let us see the petition which you had filed. Client की जरूरत नहीं होती रिवीजन बहस करने की. रिवीजन के लिए रिकॉर्ड की जरूरत है. Client is not required, except for remitting your piece. Yes. Tell us. Where is your petition? Just read your petition.
Just I had gone through this very elementary petition was that your petition is a legally married wife of Vrinda Prasad. The respondent is not maintaining the petitioner in neglecting her, due to which she is at verge of starvation. That your petitioner Seema Devi and the respondent Vrinda Prasad lastly lived together as husband and wife at Shalimar PS itna till 24/11/2012 within your honor's jurisdiction. That earlier no case of maintenance has been filed by the petitioner against the respondent at anywhere else in any learned court in India. That your petitioner husband, namely Vrinda Prasad, is a permanent employee of Tata Steel, Situa, by his personal ID in Patna, and he used to receive salary to the
Okay,
tune of
we'll see that. Yes, what do you have to say?
I have an either or argument.
Okay.
This is either a case of no marriage or it is a case of void marriage. At the outset, I will state that had it been a case of the first marriage being annulled, it would have certainly come into their favor. But they have themselves, that is the first marriage with the first husband, from which he has had 3 children. Now that marriage, this is a very peculiar, that aspect is fairly peculiar. I will draw your ladyship's attention to it. Because first an application is filed under section 11 to annul it, seeking declaration that an 11-year-old marriage, this is the first marriage I am talking about, is null and void, an 11-year-old marriage. So that TMS that was filed was in 97, that marriage would have been solemnized in 86. Now the date of eviction, kindly mark this date, your ladyship. This date of eviction from the first marriage is 15/4/96. That is the first wife, that is the wife was evicted by her first husband on 15/4/96, meaning that when she claims to have been married to me in a court in Asansol, she was actually living with her first husband at the time. Not that she was just married to him, she was living with him also. So their case of long cohabitation collapses there itself. The second concern here, why I say it is a case of no marriage and not simply a case of void marriage, is because this is not the case that they were married in a mandir. It is not the case that they were married through customs in some secluded place. It is a specific case, and they say time and again, and they have witnesses who are relatives, none of whom have been able to show even a month of the marriage, not a date. Even a month of marriage has not been able to, they have not been able to show. Now it is a specific case that they married in 1995 in a court in Asansol, and thereafter PW4, who is the petitioner,
In a court?
in court in Asansol, and PW4, who is the petitioner, has very nonchalantly and very casually come in the court and said yes, no paper was prepared there in the court. It is a court marriage, but there was no paper prepared. So this is a case of no marriage. As far as a case of void marriage with regard to marriage between petitioner and OP number 2, it is the admitted case, and here I am backed by Rajiv Thapar and various judgments that say that if it is admitted, that is a 4-fold test. This is also a certified copy, so it will get 8 of 74 of Evidence Act to get with 77. Now, this is a case where she has said that she has filed for divorce. She has filed for divorce in 97, where she was married to me in a court in 95. The divorce was granted in 99. She continued to stay with me while she was married to the other person, and she says at the same time that she was actually staying with that person in 96. So which one is true? It is either this or that. Either case it is a case of no marriage or it is a case of void marriage. If it is a case of void marriage, then there is no question of 125. There are judgments of the Honorable Supreme Court, and I will come to no strict proof of marriage required in 125. It is settled law, no strict proof of marriage is required. If they are able to show long cohabitation, then till the time the cohabitation exists, I am liable to maintain that. I will also respond. But as far as this case is concerned, that ये जो इनका ये है, this part, ये. As far as the second point, that it is a case of void marriage is concerned, the first, sorry, just a second.
She did not disclose her previous marriage in her petition?
No, she admits. She admits that.
In her main petition?
No, that is my point that I was coming to. In her petition, they have not claimed cohabitation. It is not the case that they were cohabiting for long. Kindly have the petition that your ladyship rightly was going towards. The petition that I have flagged here. This is how the petition reads. That your petitioner Seema Devi and respondent Vrinda Prasad last lived together as husband and wife. It has never been averred that they were living since 1995 till the date of filing of this petition as husband and wife. It is, and over and above that, only one date has been provided, that is 24/11/2012, and that is the date when it is said that I stopped maintaining her. Not that she was ousted, not that thereafter they cut off their relationship and there was no this thing. So as far as strict proof of marriage is concerned, that burden only comes to me when either it is invalid marriage, or it is irregular marriage, or it is a case of long cohabitation. None of them have come to their aid. There are various judgments of the Honorable Supreme Court. Now there is a judgment, Dr. Priya Banerjee, that says that even if desertion is proved at the behest of the wife and divorce is granted to the husband, still by deeming fiction, because wife includes divorced woman, it cannot suddenly not include divorced woman who has been divorced by her own conduct. Yes. So that judgment also exists. None of them comes to their aid. This judgment that they rely upon, this judgment, Captain Record Officer, OIC records, now the
I get your point.
the factual matrix here, why it was easy for the court to infer long cohabitation is because they had children in this marriage.
We'll see that.
The appellant number one here, in this particular case, had a child. Now in this case, the wife has had a child. What is the actual, how this opposite party number two has been wronged is what affords even more peculiarity to this case. It has come even in DW3 has been examined. He's an independent witness. He knows both parties since 20 years plus. He says, and I am not going into my own deposition and statement here. He says that is Ayub. He says that the quarter was given to her because the neighbors said कि आप इनको दे दो, इनकी बेटी की शादी होने वाली है. She does not have a quota, आप इनको दे
She
दो.
has a child from her first marriage.
3 children from her first marriage, and that has all come. So thereafter, and because of that, he performed Kanyadan. That has all been explained. So there was an argument on the other date that he performed Kanyadan. So that is that.
I get it. You see, I will reserve the judgment. I will not give the dictation regarding your submissions right now. You can just give a short note, please, both of you, right? You do it by Monday. Will it be okay?
Monday will be fine.
By Monday? Interesting. Let us see.
Just to rebut only one point that my learned pointed out, that
Because these timelines are important.
But
These timelines, these submissions, that there is no statement in her petition that we have not made out a case of
long cohabitation. Yes, this is an improvement. And number two, had it
We'll see that. And she also, according to him, I do not know, we'll see the records. According to him, in your petition, you never said that you were already married.
yes, that was not said.
That was a gross suppression, isn't it?
One interesting fact that I just wanted to point out. Now this is what has completely collapsed their case. Had they continued with the Section 11 divorce there, then they could have taken the plea because annulment in certain high
That
courts.
I had told him
Yes,
time and
that
again.
I know.
Because annulment, certain high courts have held
That
that
is
annulment
null and
would set
void.
the clock back.
Certainly.
So thereafter
It is
they
as
could
good as
have
null and
taken
void.
yes, they could have taken the plea there, but
As
now
good as no
that has
marriage.
come to my aid. Now that 13B has been filed, that has come.
and
to my aid.
that in one of the depositions that it has come that it was done on the behest of the respondent hearing, but that is
You can't
not on
get
record.
out of that.
But only one point to rebut my learned friend's argument that there are certain documents which have been marked as exhibits. The
And
joint
how do you
passport.
explain your not staying together? You see, a lady comes, says that I stay with a person for 10 years.
Yes.
And then she separates after and files a case for maintenance after 5 years. You see, in a case of live-in relationship, the parties,
In a case of living
in
relationship,
a case of live-in relationship, in a case of husband and wife marriage, even if the wife is living separately, husband has an obligation to maintain her. But in a case of live-in relationship, does the husband has an obligation to maintain a lady? The person has an obligation to maintain the
This-
lady, irrespective of the fact whether she is actually living with him or not. This is what is actually bothering me.
But there was no point of the husband to become a joint holder in a passbook, or
Passbook is no.
That is a separate
Or
thing. That
to-
is just a proof that you are living together.
or to become a dependent, or to make me a dependent in his records that are being maintained with Tata Cold. That is a very valid point. That what was the occasion for him to make me a dependent at
That
Tata
has also
Cold?
come in
Yes,
this
it has
case.
come in. It is marked as Exhibit 2 and Exhibit
She has never, I'll just quickly respond to that. She has never stated, nor have the other witnesses ever stated that she was actually dependent on me at any point in time. That is an important point if they're placing that exhibit. Because as far as long cohabitation, even in living relationships is concerned,
You
if
see, you
the-
have multiple points in this
Yes.
case, so you have to deal with each one of them in your
And
written
my lady,
submissions.
we will also have to see that what the trial court has held and what points it
Yes,
has taken,
certainly.
and the perversity of judgment there.
Certainly, we will see that. That is why I think that this judgment cannot be pronounced in open court. Lot of records I have to see
Yes.
and verify. So therefore, you file your short submissions
Yes.
by Monday, and I'm just reserving. Learned counsel for the parties have advanced their arguments at length. The judgment is reserved. They undertake to file short synopsis of arguments on the basis of the arguments which has been advanced before this court and the materials available on them.
I may be permitted to give some judgments also. I have
They
not
may
given-
also cite the judgments referring to the particular paragraphs in the judgment. If you are citing any High Court judgment, ensure that whether it has been tested before the Honorable Supreme Court.
Yes.
Find it out, because there are certain circumstances where judgments are cited, but it stands overruled by the Supreme Court, or
There is
maybe the
one
division
judgment.
bench of the same court.
There is one judgment that has been overruled. There was a judgment of 1988 that said that in case a woman is not a legally wedded wife, she will not be liable to maintenance. That has been distinguished in a 2008 judgment, Chand Patel. But it still speaks of irregular marriages or invalid, never of void marriages. If it is admitted that it is void marriage, there is no question.
There is a presumption, but if there
But
is
I have been
a,
able to disprove it, not just rebut it. I have been able to disprove that.
that's, they maintenance is also provided under domestic violence, right? And all the females are entitled for maintenance under domestic violence. I think some protection they are entitled to. They cannot be thrown out of the household, right?
The
But
protective
when it
orders,
comes to
residency
125, we still to see. I have not examined those judgments of Honorable Supreme Court, which talks about live-in relationships or whatever. Keeping your point in mind that it is not a case of any presumption, because there is a specific finding
admitted. It is
that so-called marriage was in 1990.
And also, by the time when she got married to me, as per her case, she was not yet evicted by her first husband.
That's right.
So there is no, actually, there is no cause of action here.
Let's see. You find it. Yes, you are there. Ready? क्या बोलना है? बताइए. What do you have to say?
During trial of the execution during the trial, the execution persons have filed the application before the judicial commissioner magistrate manner, containing that the self fact they could not be tried to a second time in the view of section CRPC, and on the basis of the charge evidence.
वो क्या
Against the-
क्या सुनिए वो क्या बहस की आप क्या बहस कर रहे हैं आपको समझ में आ you have to respond to his arguments ना. He says that the case has been आप तैयार हो गया ये प्लीज किसी से समझ गया
ठीक है.
आप कल आइए आप तैयार हो ठीक है. Criminal revision number 1717 of 2017. Counsel for the parties are present. Counsel for the petitioner submits that both the courts that the petitioner is the informant,
Petitioner is
complainant, and both the courts have passed judgments against him primarily on the ground, primarily by referring to section 300 of CRPC, and also on the ground that the petitioner has not been able to prove his case by adducing appropriate evidence.
Expert evidence.
Others we
उसी
have
पर है.
appropriate evidence of decline. Counsel for the nobody has entered appearance in spite of service of notice so far as the complainant are concerned. The counsel for the state submits that the matter be posted tomorrow for his arguments to enable him to go through the records. ठीक है? सर आपका एक मैटर था पास होगा? आप लोग अपना अपीयरेंस देंगे.
Yesterday at 10 p.m., one of the petitioner had come. His wife has died. On the last occasion, this was brought to the notice. That wife who was the petitioner in this case had died therefore.
तो पहले ही
Then, yes. Thereafter, this case has been ordered to be listed for today for final argument. When I was praying, will not be one accommodation because not like tomorrow I have to go to Gaya to perform this Shraddh, etc. So, in the next week, not Tuesday or Wednesday, any date my Lord may fix it. So that not I may be able to assist the Lordship. This case conviction has been recorded in Session 498
अब
case.
सीनियर एडवोकेट टाइम मांगे तो हम क्या ही मना करें.
जी नहीं हमको कल रात में ही आप
कोई
10
बात
बजे तो आए थे ये पटना से
ये नहीं दिखा है that no further adjournment.
जी हाँ वो हम
2001 का मैटर है सर कंप्लेंट.
जी हाँ, हम फर्दर टाइम ले लेंगे नेक्स्ट
कोई
वीक
बात
एनी
नहीं,
डे
आपको कब करना है?
एनी डेट ट्यूसडे और आफ्टर मंडे एनी डे
ओपी नंबर 2 की तरफ से कौन है? मिस्टर कौशिक सर्किल वाज अपीयरिंग इन दिस केस. आई थिंक उनका वकालतनामा तो है. ओपी नंबर 2 आर यू जूनियर ऑफ मिस्टर कौशिक सर्किल? सब एक जैसे दिखते हैं.
Sir,
उनसे पूछ रहे हैं आर यू जूनियर ऑफ मिस्टर कौशिक सर्किल? वो जो पीछे खड़े नहीं वो उस समय थे क्या? Was he there? Learned counsel for the learned senior counsel for the petitioner, Mr. A.K. Kashyap, submits that he has been recently engaged in this case and he has to go through the records and for some personal difficulty he is not eligible to move. He submits that the matter will be posted next week. Post this case for final disposal on 1st of October.
फर्स्ट
1st October.
ट्यूसडे
अगला हफ्ता होगा ट्यूसडे. ठीक है. Nobody appears on behalf. You're for the state? No. Nobody appears on behalf of the state and opposite party.